welcome to this joint Landmark Chambers and Womble Bond Dickinson webinar. My name is Neil Cameron, QC, and I will chair the session today. And I'm joined by Kevin Gibbs and Lorrae Hendry from Womble Bond Dickinson and Matthew Henderson from Landmark Chambers. And I'm going to introduce them in a moment, but here are the housekeeping points. Your microphones are automatically muted, so you will not need to adjust your own settings. We very much welcome questions, and the way to raise a question is to use the Q&A function. So if you can put your questions in writing using the Q&A function, we will try to answer as many as possible at the end of the session in the discussion session. The webinar will be recorded and is being recorded, and you'll receive a link to the presentations and the recording at the end of the webinar. And if your connection is lost, I hope that it won't be, but if it is, you can rejoin again by clicking on the same link. So that's enough housekeeping. Let's get into the Transport and Works Act. The Transport and Works Act 1992 is nearly 30 years old. And it may be thought, and I think it has, that it's served its initial purpose. And what's the evidence for that? Well, we've seen a number of transport schemes and other schemes around the country, but I'm thinking particularly of transport schemes and the re-emergence of trams in some of our major cities. And a lot of that is due to this Act. Times move on. We now have the Planning Act 2008. We have a development consent order regime, and some may think there's time for change, but that's one of the things we're going to consider. And to help us do that, we got Kevin Gibbs, who's a Senior Counsel and Head of Strategic Planning at Womble Bond Dickinson. He's particularly well qualified to deal with this because he's dual qualified. He's a solicitor and a chartered town planner. And his expertise includes CPOs, DCOs, and I don't think I'll go on with the acronyms, but Transport and Works Act orders, harbour revision orders, and the like. We've then got Lorrae Hendry, who's a Managing Associate at Womble Bond Dickinson, and she has very deep knowledge of infrastructure projects with a particular focus on transport, but she also advises on a whole range of other matters, planning, environmental liabilities, and the like. We then have Matthew Henderson from Landmark. He practices in planning and environmental law, and he's advised on and appeared at examinations in relation to DCOs, advised on Transport and Works Act orders, and he regularly appears at public inquiries. Well, that's enough for me, so I'm going to hand over to Matthew Henderson, who's going to start by considering the Act and other development consent mechanisms.
Thank you very much, Neil. So my talk today deals as a very brief overview before the other speakers come in with the Transport and Works Act and a series of other development consent mechanisms. By way of overview, we've obviously got the 1990 Act that everybody's familiar with. We've got the Planning Act 2008, the Transport and Works Act 1992, hybrid bills for things like HS2, and a range of other sector-specific mechanisms. The Electricity Act is one example. Today, I'll deal principally with the Transport and Works Act and also the Planning Act 2008. So if we start with the Transport and Works Act, the types of projects. So Section 1 is the starting point for this. It allows an order in relation to or matters which are ancillary to the construction or operation of a transport system of any of a number of different kinds such as specified, railways, tramways, trolley vehicle systems, and then systems for a mode of guided transport which are prescribed by order. We've got 2 orders. The 1992 order is the principal one, the 1997 order amends that, and it prescribes a whole series of additional types of guided transport. I've listed them there, but things like monorail, road-based with cable guidance, for example, track-based as well. In terms of what does this mean? So we start with railways. We've got a definition within section 67 of the Act. It excludes tramways and miniature railways unless they cross a carriageway. And in that respect, it has the same meaning as in the Planning Act 2008, and that's section 253 of the Planning Act. It's also important to note that tramways are not within the Planning Act, but they are within the TWA, and therefore this is the principal consent and mechanism for tramways. Trolley vehicle systems, again, there's a definition in section 67 of the Act, so that's vehicles which are constructed or adapted for use on roads but without rails. And that's where they're under electric power, and that power is transmitted by overhead lines or wires. In terms of those which are prescribed by order, the intention here was to give a mechanism by which technological change could be accommodated, such that the Act could keep up with technological change. Guided transport has itself a wide definition, that's again in section 67 of the Act. Guided there means by external methods of guidance. It's different in that regard to the trolley vehicle definition, which talks about modes of power. We're dealing solely with questions of guidance. Examples, for example, the London cable car order in 2012 came within that wider scope under the orders. Moving on then to section 3, this deals principally with inland waterways and the interference with rights of navigation. In terms of inland waterways, that excludes areas which are managed or maintained by harbour authorities. And again, as with section 1, there's the ability to extend the matters fallen within section 3, and that's been done by order. Again, the principal order being in 1992, subsequently amended in 1997. And I've included a series of examples of what those orders include, things like land reclamation, navigational aids, observation structures. The principal focus of section 3 is dealing with marinas and other harbour works. So if that's the Transport and Works Act. If I turn now to the Planning Act, section 31 of the Planning Act 2008, development which is or forms part of a nationally significant infrastructure project requires consent under the 2008 Act. It's important to note section 1, subsection 1A of the 1992 Act, which makes, by way of a late amendment, the operation of the 1992 Act subject to the Planning Act 2008, such as to deal with matters which might otherwise overlap. Section 14 of the 2008 Act gives us the definition of a nationally significant infrastructure project, an NSIP. And for our purposes of comparison, it's useful to note what this includes. So, for example, highway development, construction or alteration of harbour facilities, railways, rail freight interchange. So potentially scope for a similar range of projects, but it's important to note that those NSIP are all themselves subject to limitations and thresholds. So, for example, highway development thresholds within section 22, the 2008 Act deal with the amount of area, so 15 hectares in terms of motorways and 12.5 hectares in terms of other highways. So those are the thresholds above which you must be to get within the 2008 Act. Similarly, railways, section 25 of the 2000 Act has thresholds for both the construction and alteration of railways. I've listed them there, but important points to note, for example, 2 kilometres of 2 kilometre continuous stretch of track not being on operational land of a railway undertaker. Those sorts of questions delineate what would fall within the 2008 Act from the 1992 Act. So turning then to consider the scope of an order under the 1992 Act. Section 5 is our starting point. It includes those matters set out in Schedule 1. I've listed just some of them. There are a great number within Schedule 1. It's important to note as well that it's an inclusive provision, it's not exclusive. And when you look through the list, there's a number of obvious and important matters, principally construction, alteration, maintenance, engineering works, but also dealing with matters such as the acquisition of land, the creation and extinguishment of rights, and then a whole series of other practical measures for both the preparation and operation of projects. So things like surveys, soil samples, but then later on tolls, fares, the making of bylaws. It's important to note as well that Section 5 and the breadth of Section 5 allows an order to relate to more than one scheme or more than one system or mode of transport. So there's an inherent flexibility within what an order may cover. It also deals with the application, modification or exclusion of statutory provisions, and also deals with amendments, repeals and revocations of statutory provisions where they are of local application. It's important to note that that's power restricted to provisions of local application. Staying with the 1992 Act, it's important to note that it does not confer planning permission, but this can be dealt with in two ways. Firstly, by requesting from the Secretary of State a direction deeming the grant of planning permission, and you get there via Section 16 of the 1992 Act, which amends Section 90 of the 1990 Act, in order to give the Secretary of State the ability to deem planning permission in that manner. And of course, you can also get planning permission from the local planning authority under the 1990 Act, although if you were to do that, you need to think about approaching matters sequentially. Section 19 of the 1992 Act, it's still in force, but it deals with the disapplication of the needs for consent under the Coast Protection Act. That itself has been repealed, but I noticed a matter of interest, and that was repealed in 2011 by the Marine and Coastal Access Act 2009. And then importantly for a lot of schemes, Section 15 of the 1992 Act, this permits the Secretary of State to make regulations which deal with the assimilation of procedures. And we've got two sets of regulations. The 1992 set are the principal ones amended by those in 1993. This deals with scheduled monument consent, listed building consent, conservation area consent as well. And the effect of the regulations, in short, is to assimilate the two consenting procedures, such that if you make an application either within 10 weeks of your application for the order or later than that, but with the direction from the Secretary of State, those procedures can be assimilated and essentially dealt with together. Similarly, there's the power to deal with applications under Part 7 of the Transport Act 1968, concurrently with an application for an order under the 1992 Act, and that deals with, for example, the reclassification of waterways. Finally, before leaving the 1992 Act, one power that I will note, and I think Neil will come back to, is that in Section 5. So it's the ability in principle to exclude other statutory requirements. That could include other statutory consenting mechanisms or requirements. But it's important to note that as a matter of policy, the Secretary of State will only do so in very exceptional circumstances. Turning now to the Planning Act 2008, think about the scope of an order here. Most obviously includes both construction and use. I refer you there to Section 157 of the 2008 Act. But also, unlike the 1992 Act, it deals comprehensively with a whole series of other consents that might be required, for example, planning permission, and I've listed a whole series of other statutory provisions which are swept up, most particularly the Listed Building Act. And also under Section 149A, the need for a deemed marine licence can be swept up in the same application. Other matters of scope, Section 115 allows for associated development. Section 120 deals with a whole series of matters which are ancillary to the development for which consent is provided. That takes you through to Schedule 5, which contains another extensive list, similar to the Transport and Works Act list that I went through a few slides ago. It covers matters such as the diversion of watercourses and highways, statutory undertakers' rights, operation and maintenance of transport systems, tolls, fares, those ancillary matters that you need to get your scheme up and running. And then finally and importantly, as with the 1992 Act, it also includes the power for the compulsory acquisition of land, that's section 122, and then specific circumstances, so only if it's required for development for which the DCO relates, or required to facilitate, or it is incidental to that development. In terms of procedure, touch on this very briefly. I've given you the specific statutory provisions on this slide, but it's important to note that there are quite significant differences in the two schemes, in particular because of the front-loaded approach in the Planning Act 2008. I'm thinking in particular the need for statements of community consultation under section 47, the follow-up consultation to that under section 49, the introduction of an acceptance stage for DCOs, and then the procedure for examination, which is, I think it's fair to say, more complicated or more complex, at least in its statutory provisions, than under the 2006 rules and the 1992 Act. So with that comparison, I'll hand over now to Neil, who's going to think about some of the pros and cons of different consenting mechanisms.
Matt, thank you very much indeed for that. I'm now going to, as Matt said, look at some of the pros and cons. But before I do that, I'm going to have a look at the history. So why have we got the 1992 Act at all? So I look back to what the then Under Secretary of State said in the second reading of the then Transport and Works Bill, and in the course of his speech, it was Patrick McLaughlin, who of course went on later to become Secretary of State for Transport and various other roles. But he pointed out that in 1838, Parliament was able to deal with 62 private bills that had been deposited, but by 1991, they were struggling to deal with half that number. And as he put it in his speech, it has become clear that Parliament is not prepared, as it once was, to see numerous bills brought before it to authorise such schemes and works, which I think was code for the fact that MPs were fed up with sitting on private bill committees and hearing lawyers drone on and experts give evidence. So the solution was to get works bills out of Parliament and allow schemes to be authorised by the Secretary of State, aided by an inspector. And that is why we have got the Transport and Works Act. So when we seek to judge has it worked, it's really against that background. So the ambit of the regime, well, Matthew's covered this to a large extent, and the big headings are railways and trams and inland waterways. There is, of course, the Act includes mechanisms to extend the ambit within those general headings. So you've got works which interfere with rights of navigation. There's a 1992 description of works interfering with navigation order, which sets out the details. And there are opportunities to expand its operation, but few have been taken. What could it not cover? Well, the section 33, subsection 2 of the Planning Act 2008 says that if a DCO is required, a development may not be authorised by a Transport and Works Act order. So what's that flexibility? Well, when the bill was brought in, Parliament was concerned that the new regime wouldn't have the same flexibility that private bills had. So what did they do about it? Well, section 2 is an example. They gave the Secretary of State power to prescribe modes of guided transport to bring them within section 1. And that allows quite a lot of flexibility. I'm not quite sure you get as far as that scheme on the left. But I think, and I express my own view, that it's somewhat disappointing that the Secretary of State has not used that power which Parliament envisaged that he would use. Now, when we get to section 5.1, what are the matters that can be included? And as Matthew said, it's an inclusive provision, so it includes those set out in Schedule 1. There's a wide range of matters that a Transport and Works Act order can cover. It is a statutory instrument and is not just the matters in Schedule 1, but that's a good start. Another place to look is in the model clauses, because the model clauses give you a very good indication of the ambit of the order. But as most of you know, it covers compulsory acquisition, highways provisions, stopping up of streets, street works, and a whole range of interventions that can be made authorised by a Transport and Works Act order. So it's actually a powerful tool. We have the Dean planning permission provisions, which Matthew's covered, so I won't go back on that. That's under the Town and Country Planning Act, but it operates at the same time as a Transport and Works Act order, and any inquiry into a Transport and Works Act order will also consider the application that planning permission be deemed to be granted. And at the same time, you can use the provisions in relation to listed building concern. Now, I am going to dwell just for a moment on section 5.3. Matthew's referred to it and the guidance that this should be used in the old guide, the 2006 guide to Transport and Works Act orders. But this should be used in very exceptional circumstances. It seems to me that that is again a disappointment, because section 5.3 is wide. An order may apply, modify, or exclude any statutory provision which relates to any matter as to which an order could be made. Now, that is a wide power. Parliament intended those applying for orders to be able to use that power. And I think it's slightly disappointing that the Secretary of State thinks that it should only be used in exceptional circumstances. And I think Secretaries of State should be slightly more willing to use it. Now, so what are the advantages and disadvantages? Well, a lot of people regard the inquiry procedure as a disadvantage. They can be lengthy, causes delay, expense, and can require the attendance of witnesses for many days. So it could tie up somebody who's got other important responsibilities, who has to sit, listen, and then give evidence. So that is maybe seen as a disadvantage, for example, compared to the DCO examination process, which is more front-loaded. But an inquiry, there are clear rules for statements of case and evidence. A promoter can use the initial part of the inquiry to establish the justification for the scheme, and those opposed who have particular interest to protect can participate in part of the inquiry. So a well-run inquiry does not have to tie up people for too long. That is, those who are concerned and who are affected by the scheme. They include statutory objectors who have a right to be heard. And it's an advantage, I think, that it allows for a thorough examination of the scheme. So particularly those who are opposed can see that their objections are carefully considered and heard. Now, I think another advantage is that, and perhaps I'm harking back to the old days before we had a plan-led system, but there's no equivalent to section 104.3 of the Planning Act. So there aren't national policy statements, and you don't have to make the decision in accordance with the national policy statement. So you're not tied down by that. I mean, some people would say that's an advantage, but it reduces flexibility. And the other, I think, quite interesting thing is that section 38.6 does not apply to the determination of deemed applications for planning permission. Now that may be controversial, but I think it is resolved by the Samuel Smith case, which dealt with an Electricity Act consent going through the deemed planning permission process, and it was determined that section 38(6) does not apply. So it's an advantage that you have a flexible approach. So what conclusions do I come to? The first conclusion I come to is that the Act does achieve its intended purposes. It replaced the private bill procedure, but it does so in a sensible way, which allows schemes to be permitted and for objections to be heard, examined and considered properly. Now, my view is that the current system could be used more flexibly to make it more effective in operation. And I'll just give some examples of that. The Secretary of State could be freer in his or her exercise of the Section 2 powers, that's making orders in relation to guided transport systems. There could be greater use of Section 15 powers. They've been used for listed building consents, and in the days when we had them, conservation area consents. But for example, you could have a regulation dealing with marine licensing, equivalent to Section 149A in the Planning Act 2008. What else could the Secretary of State do? The Secretary of State could reissue the guide to procedures, make it more up to date. Who else can help? Inspectors. You could have more extensive case management directions, ensure effective case management of inquiries. You could consider more effective use of round tables. That would have to be subject to the agreement of the parties. But all those things could be done, all within the current system. And what could promoters do? Well, if they want a one-stop shop, they could make more extensive use of Section 5(3), and the Secretary of State could help by being more flexible about that in relation to exceptional circumstances. So my conclusion is that there are many advantages, but it could be used more effectively. So on that note, we haven't seen a scheme like that yet, but we might do. I'm going to hand over to Lorrae.
Thanks very much, Neil. Today I'm going to talk about sort of recent policy developments for transport schemes, infrastructure generally, just to see if we can pull some themes coming from central government in relation to sort of what we can expect to see in infrastructure and in transport specifically over the next few years. I think it's safe to say that infrastructure generally is having a bit of a moment. There is a lot of policy that's out there at the moment about how Britain will build back better past, post-COVID, the COVID-19 pandemic, but also how we're going to achieve our net zero target for 2050. The first thing I'll just quickly talk about is net zero. Obviously, this is old news. We all know that we now have a legally binding target to achieve net zero by 2050. I've just included that in the slide here, just to give you that sort of the roadmap as it was as to when we got that. The reason I'm bringing it up now is because it's really a very, very main thread that comes through in all of the policy documents. It's very much on the agenda. It's very much the sort of focus of a lot of the policy that's coming through about how we're going to achieve this net zero target. And I think it's quite relevant for some of the sort of threads that I'll pull from the recent policy papers we've seen come out of government. The other reason that it's important is you can see transport is leading, unfortunately not the race it wants to lead, in greenhouse gas emissions as a sector. Energy has done very well over the last few decades in bringing down their greenhouse gas emissions, obviously less coal-fired power stations, more renewables, hence a reduction in greenhouse gas emissions. Transport, although it stayed fairly consistent, is now in the lead and is the focus of government and sort of the decarbonisation of it. The policy, I guess, space over the last 6 to 12 months has it feels fast moving, quite dynamic at the moment. Whether it will sort of result in that in sort of real action on the ground will be seen, but I thought it would be helpful just to sort of pause and see where we're going. So this time last year we had the decarbonisation of the transport consultation paper setting the challenge. Now that was or is a precursor to the transport decarbonisation plan. We haven't seen the transport decarbonisation plan as yet. It's been delayed, I think, a couple of times so far, although still scheduled to be delivered in the spring this year. So we will wait and see what comes out of the plan itself. I'm not really expecting there to be any big surprises as to what the focus will be in that plan. I think we will see a focus on promoting people to public transport, green public transport, away from the private car. We'll see electronic vehicles as a focus and the infrastructure required to charge them. We'll see a focus on kind of green freight and how we can achieve that, together with, you know, all things sort of aviation and shipping as well, which aren't to be forgotten in the transport sector. But that sort of, you know, again, as I said at the beginning, it's that net zero by 2050, and that's, you know, the thread that's coming through. And that also brings in the 10-point plan for the Green Industrial Revolution, which is a paper that was released in November last year. Again, another fairly short paper that sets out the sort of 10 areas that the government would like to focus on in achieving net zero. And another, the sort of the main point from that, I think for the purposes of today, is that that focus, that sort of drive to shift from the private car to public transport, in buses, railways, and sort of greening up transport in that way. The other thing that I wanted to just quickly touch on, because it's quite an important document, is the National Infrastructure Strategy. It was released in November last year, so it's been around for a little while. There's a fair bit of commentary available on it if you are interested, but essentially it sets the scene for the government's view of where infrastructure should go and how it should be kind of progressed throughout the next sort of 5 years. I think the strategy has to be updated every 5 years. So I've set out the goals from the National Infrastructure Strategy. So there's 4 goals: levelling up and strengthening the union. Levelling up is a phrase you'll hear me say quite a bit this afternoon, because it again is another thread that kind of comes through each of the policy documents. Essentially, it means recognising that London and the Southeast has seen a lot of activity, a lot of development and a lot of focus over the last, you know, however many years or historically. And so what they're proposing is to push more funding out into those areas that have historically not had that funding, to sort of level up, essentially. So it's quite a literal thing. The decarbonising the economy and adapting to climate change. Interestingly, the strategy talks about restoring many of the rail services lost in the beaching cuts. There's a huge emphasis on buses as a way to, you know, remove that reliance on private vehicles, and the sort of the decarbonising generally. So we've got the third goal is supporting private investment in infrastructure. And that's being done by sort of various ways, but in particular, one of the ways I'll touch on this afternoon is the National Infrastructure Bank, which is in the process of being set up to help facilitate, fund, encourage private investment in infrastructure. So we will look at that in a second. Accelerating and improving delivery. I'm sure many of you will have heard of Project Speed, which is a government task force that was developed last summer to look at infrastructure projects across the kind of remit of what we might think of infrastructure, from the seed stage right until the open for traffic or open for business stage. thinking about ways that it can be sped up. I think it's interesting in the context of Transport and Works Act, because from what I have seen, and do correct me if I'm wrong, I haven't seen any real focus on ways that we might improve the speed or efficiencies of the Transport and Works Act process, and perhaps some will say that it doesn't need it, but I know that that's one of the points that Kevin will be talking about, so it'd be interesting to hear thoughts on that. As I said, one of the focuses is on alternate modes of transport, how we get people out of their cars and into green public transport. There's a Bus Back Better, building on the Building Back Better policy that the government has, which is a paper that was released just in March this year. Huge amounts of money being put forward to fund buses across England. Again, it's looking at those areas that don't currently have the sort of London level of bus where the demand is there. So very much using London almost as a benchmark, and then seeing how many other regions in the UK can be brought up to that standard. Again, it will be interesting to see how much take up there is, but that's definitely the focus. I think based on the sort of policy papers, the bus is having a bit of a renaissance, and rightfully so if we can have zero emission buses. I won't touch on this slide, I'm conscious of time really, but essentially just a quick snapshot of where the funding comes from, depending on the different aspects of infrastructure. No huge surprise that transport is mostly central government funded, being that most of the money is probably in roads, as opposed to the sort of smaller elements, which might be your rail or your buses or privately run public transport type things. So energy utilities and digital infrastructure, it's much easier to see how revenue might be raised for private investment, and hence you have a bit more of an uptake. So I wanted to just touch on the National Infrastructure Bank, because it's all very well to say there's a massive focus on local schemes in regions that have been deprived or are in need, but if those regions are deprived or in need, then they presumably are, the funding needs to be there as well in order to unlock that. There can't just be a statement that says you must do this without also saying, and here's the means for you to do that. So the National Infrastructure Bank is being set up. It's got two core objectives, again, no surprises there, net zero by 2050 and support regional and local economic growth, so essentially levelling up. So you've got those two threads coming through once again. This is interesting because I think, with particularly in the Transport and Works Act sector, the focus on alternate modes of transport, the need for innovation in order to meet net zero, we have to be thinking creatively. Does the Transport and Works Act process allow for too much innovation when it comes to sort of guided busways or different modes of transport? Is it something that we can use more of in order to meet our targets? And is the National Infrastructure Bank something that we can get funding from, loans for local authorities, to sort of bring about those new schemes so that we can have that sort of greener public transport in local authority areas? Interestingly, the bank will do private sector and public sector funding. Public sector projects don't need to show that they will be sort of revenue raising, unlike private sector, but it is a loan system, so there will need to be the ability to pay it back. It'll be the other interesting thing about the Infrastructure Bank actually is the advisory arm, which I think is a really interesting idea. If it works, I think it will be really useful. The point of it is to recognise those local authorities who might want to approach the bank for a loan, but perhaps don't quite have the expertise to pull the projects together or develop the application required in order to get the loan. So that will be an interesting kind of leg up for some of those local authority areas that don't currently have the resource or perhaps the expertise, and it'll be interesting to see how much of a knowledge bank that becomes. The Leveling Up Fund is the fund available to do all this levelling up that the government keeps talking about. 4.8 billion cross-departmental fund. It's really interesting, the Leveling Up Fund, because it's a fairly complex in who can apply for it, how many times you can apply, what you can apply for, but essentially they are looking for projects that are in those areas where there is a need kind of known, and also they're looking for projects that will have that visible impact on people and communities. There's a focus on the environment, there's a focus on sort of instant reward, or instant sort of problem solving. There's also this element, again, a bit like the advisory arm of the National Infrastructure Bank, on helping to support local authorities who may not have that inbuilt expertise about to bid for money from this fund, and to make sure that they're putting the best projects forward. I don't have time to go into the detail of sort of how you go about bidding. There is a prospectus that was issued in March this year that does go into a bit more detail about how that works, MP support that's required, how you might prioritize projects and that sort of thing. But I guess the key takeaway is that it's there, it's available for transport projects. It can be used sort of up to £20 million in funding per project, and to the sort of an exception for sort of more complex road schemes. But as far as projects that might be brought forward under the Transport and Works Act order, you've got this possible kind of, I guess, pot that you could draw from. The one thing it probably doesn't do is solve the political discussions that have to happen in these sort of funding areas, and things that cross local authority boundaries. So I will end it there. These are just a couple of my final points. As I said, levelling up is a massive focus. Trying to bring those local authorities forward that don't have maybe the capacity or capability to deal with it, and the what does project speed kind of mean in the Transport and Works Act regime. So that's me. I'll pass it over to Kevin.
Thanks. Thanks very much, Lorrae, and welcome everyone. I'm going to very quickly go through the potential opportunities that exist for possible reform of the TWA, as I'll call it. Just get the next slide up. There we go. So Lorrae's done a whistle-stop tour of the decarbonisation debate, the net zero targets, and looking at that, and also some of the advantages and disadvantages that Neil mentioned in his talk, and the real need at the moment across a range of sectors for improving the speed and certainty of consenting, and the need for building back better, to have good and fast infrastructure. I thought maybe there will be some areas that we could look at for intervention to investigate potential changes to the system. As Neil mentioned, the Act is now 30 years old, and many of the regulations, rules are fairly dated. So now might be a good opportunity to look at some changes. So I've looked at 4 areas. There's the policy changes potentially, change of mode, which both Neil and Matthew touched on, consultation and deadlines. So looking at the policy input and the interface with policy and the TWA, as Neil mentioned, unlike the DCO processes, which is sort of in a way, I suppose, straitjacketed in a way with the NPS, there's far more flexibility in terms of the touching on policy and the means by which the inquiry process progresses. In terms of how policies are considered, these are the considerations. NPPF, national transport and local policies are taken into account. But one of the potential opportunities could be to look at the form of decarbonisation policies that Lorrae was talking about, and almost have a encouraging type policy, something specific to TWAs potentially, but encouraging net zero policies, which may open the opportunity for making funding applications and encouraging schemes to come forward from stakeholders, from transport operators and local authorities potentially, having some sort of, I suppose, proactive type policy that would help that process. The other thing I suppose a policy would do, and not to try and limit the flexibility, but with the inquiry process, as those that are used to going through these sort of inquiries, the Secretary of State does set out statement of matters for the consideration at the inquiry. They're pretty similar across many of the inquiries into transport schemes, and maybe a good way of bringing it all together is to sort of bundle them up so that you have clear assessment criteria for these sort of projects. It's made open, I think, with a sort of general policy that is TWA specific. It sort of opens it up to a wider and transparent audience. So that was one means by which I thought that would be a means to reform the system, is looking at policy interface. The second is, and again, this has been touched on by both Neil and Matthew, in terms of the modes order, and as Matthew went through the guided modes order, which was made back in 1992, and again updated in 1997 with an amendment, it does allow for a number of modes to be consented through the TWA, including monorails and such like. The one difficulty, though, is that if there are modes out with the current regulations, the actual means by which the order is changed is to go before both houses of Parliament, which can be very time consuming. And so one of the possible changes or investigation that could be made is to look at amending the section to make it more palatable or easier effectively for Secretary of State or stakeholders to make applications to Secretary of State for different types of guidance systems. We don't know what they are yet. I mean, there are, transport innovation is always progressing, and there is and as I think Lorrae mentioned, that transport innovation is obviously positively encouraged by the government. So a means by which the modes order can be changed without having to go to the House of Parliament could be a way forward. The third area that to investigate in terms of reforming the TWA is to look again at consultation. Now, as many people know, consultation has been a ripe area for legal challenge across the planning system. And unlike the DCO system, as Matthew mentioned, the consultation guidance is very minimal under the TWA. Effectively, you need to provide a consultation report, but not much more guidance. There's extensive guidance in terms of who to consult, in terms of bodies, mostly on the compulsory acquisition side of things. But in terms of how to consult and who to consult and what form of consultation is fairly light touch. And I wouldn't suggest going to the extent of the DCO, which has, as Matthew mentioned, has fairly complex and very time-consuming consultation procedures, but something that could be more directed. So in terms of timescales and how to consult, could be something that may be brought into the system. And I suppose that what we'll be looking at there would be just to really to sort of change the balance in terms of adequate consultation. I mean, at the moment, there is no adequacy of consultation step, but something that would, I suppose, try and minimise challenge risk would be what I would think we'd be looking at in terms of consultation. So the last area of investigating means by which the Act and the regulations can be reformed. As I say in the bullet point, the legislation is fairly old, as is the regulation and guidance. I've put up a brief comparison between the timelines for DCO and a TWA order, and effectively the DCO does have a fairly tight deadlines in which the examination must take place, and then also timelines for the recommendation and again for the decision. Whilst the TWA has a time limits for inquiries, as all inquiries do, there could be, one could look at perhaps mirroring the sort of DCO system in terms of, how long it takes for the examination completely. But I think the bigger area of investigation would be looking at the decision-making process, because there is no time scale or deadline for the decision, either the recommendation by an inspector or the Secretary of State. And there have been occasions where orders have been, inquiries have taken place, and recommendations may or may not have been made, but the decision takes some time after the inquiry takes place. And I think that would help if there was some sort of certainty as to the decision-making process. It happens under the Planning Act, so I can't see why we couldn't have something that is that assists in decision-making. That's all. I'll just to conclude. Sorry, there we go. Yeah, so bringing in the decarbonisation debate, looking at where we are with, it's a sort of good time, I suppose, to think of amending the TWA to possibly improve it, reform it. We have the white paper looking at planning system generally being reformed, and all these threads coming together may be a timely opportunity to consider the changes that I've set out, and possibly more. That's all I've got to say. So we do have a poll. I hope I get this right. There's a poll about, is it time for reform of the TWA and associated rules and guidance? So this, we'll see whether everyone is paying attention. So I'll launch the poll. It'd be good to see what sort of response we get. So that is now launched, and I'll hand back to Neil.
Kevin, thank you very much indeed. That was excellent and thought-provoking. Can I just, while everybody's doing the poll, we've now got a chance to deal with some of the questions, so we're going to deal with that. Somebody asked whether they're going to get the presentation slides afterwards. The answer is yes, you can, and I think you'll be sent them. If you're not, blame me, and if you get in touch with Landmark, I'm sure we'll send them to you. Just on questions to consider while we getting the poll results. It's very exciting. I can see them coming up and changing on the screen. One of the things that the question that has arisen that I'd like to raise is, Lorrae, you focused on the Build Back Better agenda, levelling up and the like. Yeah. And really my question that I'd like us to discuss is, do we think that the present system, the TWA regime, is up to delivering the Build Back Better regime in the timescales that government is envisaging? So perhaps, Lorrae, would you like to start with that, and then others can contribute?
Yeah, absolutely. Happy to sort of, I guess, set the scene. I mean, it's very clear from policy that we and the net zero target is ambitious. It will need sort of that innovative thinking. There should be that encouragement from government for different ways, different modes. And from what we've heard today, I don't know whether the TWA process is flexible enough to kind of encourage innovation. It may be able to deal with innovation. It may not be very quick in dealing with innovation, taking some of the points that Kevin has made. But what would be interesting is to see how project speed then plays into that, because I think even if the TWA process could allow for some, different types of transport modes and that sort of thing, whether or not it would do it quickly, I think is probably the bigger issue, because there's certainly no indication that the government want any of this infrastructure to come through slowly.
Yeah. Do other people have views on that? I mean, I was thinking, looking at Kevin's slide, there was a picture of a canal, how in the 19th century, despite a fairly cumbersome method of getting bills through Parliament, most of our railway and canal infrastructure was built using those schemes, and a lot of it got built. So they got through it. So it seems to me where there's a will, there's a way. Mm-hmm. And certainly our current system could be speeded up. But somebody might say, well, that was all very well, but the only people who could object were those who could afford to pay some grand parliamentary agent, and we now live in a more democratic world. But other views?
I think I would only add that I think there is an opportunity to accomplish what Lorrae was suggesting, because it's more popular than you think. I did some rough maths, and 7 orders have been made by the Secretary of State this year already, compared to 4 DCOs.
I was just going to ask what the comparison was to DCOs. Yeah.
And last year, 15 DCOs compared to 10 TWA orders. Rough maths, I appreciate I was counting on the Secretary of State's own figures, but in that region. And so I think actually that illustrates an opportunity that's subject perhaps to some of the reforms that Kevin was talking about, but not wholesale, I don't think. There is an opportunity to use something which is used in practice to better effect.
Yeah, I mean, I would say, Neil, I agree with you that actually it has been a fairly good system for consenting over the years, but I think it's just got to catch up with changes. That's all. Nothing. I wouldn't say a wholesale change, because I mean, frankly, those practitioners dealing with DCO system have got real issues now because of the time it takes, the sort of detail that one goes into it, DCO examinations, getting quite frustrated. So in a way, both systems probably need a bit of a change. And I know the NPSs are being looked at, and maybe that's the means by which the government will provide an opportunity for DCOs potentially to be quicker. But I think there's a sense, there's an appetite for some form of reform to the TWA, and particularly now where we do have fairly demanding deadlines to meet climate change emergency and the net zero targets.
No. I think the solution could be a bit of both. Speed up the current process, put time limits on the Secretary of State's decision, make the inquiry process more effective, give the guidance on consultation. A lot of that could be done by policy. You could even have a policy statement which encouraged movement to net zero. Do that so you don't delay projects, and at the same time look at whether the system can be reformed. So I would do both. I wouldn't throw it out at the moment. I think I could try and make it more efficient while stepping back and saying, do we need greater reform? But shall we move on? We've got some more technical questions, one of which is closing and diverting of footpaths which cross railway lines within the powers of the TWA 1992. Who would like to have a go at that one? Matthew, is that one for you? You'd look very pleased to be given that.
It might be, as I scrabble to get up Schedule 1. I'm not sure I know the answers immediately off the top of my head. I suspect it goes back to the Section 5 point, Neil, that you were talking about, and the scope of matters which can come within.
The answer is you can interfere with highway rights, I think is the answer. And that is just the type of thing that you do on a very large number of Transport and Works Act orders, because you might be interfering with highway rights when you put in a tramway, you interfere with the rights of others to use the highway, you change the use of the highway, so that you can do.
Yeah.
Paragraph 4 is Schedule 1. I've looked it up now.
That's the proper answer, rather than me just saying, yes, you can do it. Now, there's another question here we've got, is would it help to revive and update the 19th century Light Rail Act, which was intended to cut the costs of building rural railways? Now, I think, Matthew, this is something you know the answer to, isn't it? I mean, you know the answer to all of them. But this
I'm not sure about that, Neil. I think my view on this is no. The fact that an act from 1896 wasn't repealed until 1992, I think is the starting point for thinking, well, should we go back to that? And I think my view is definitely not, because any reform would need to be very extensive. Essentially, the provisions there required a three-part approach: get your light railway order, get your CPO, get your planning permission. Whereas the trend, if you look at the Planning Act, is to do everything together in a comprehensive manner. And that to me seems to be a much better approach, especially if we want speed and we want to build back in the way that Lorrae has talked about.
Just going back to perhaps to Kevin on the reform front, what could be done to make the Transport and Works Act order more of a one-stop shop?
Yeah, I think many of the things that we've chatted about actually would assist. Certainly, other consents and licenses. I mean, that would be an area to look at actually, where you've got the possibility to have, for instance, Schedule Ancient Monuments, list of buildings and conservation area consents brought into the system, as Matthew was saying in his talk. Others are more difficult, so open space, habitats regulations, environmental permitting, etc. There could be an area for accommodating more of that within the system.
I think that's right, and I think Section 15 could be used a bit more extensively.
Yeah, I think Section 15 would be the answer.
Yeah. We had a question about the relationship between the Transport and Works Act order process and special parliamentary procedure. And I think the answer to that is Section 12, that if you do, say, for example, try and take land without replacing it, or try and acquire commons and open space without replacement, then there is a provision which it can go to special parliamentary procedure. And I think I've certainly had experience with Transport and Works Act case where it was going to be subject to special parliamentary procedure, and we went to the inspector on the assumption that it would then go to special parliamentary procedure. So it didn't in the end, but it can be done. So that's just one of the questions that we've been asked. I think we've probably gone beyond everybody's time limit, but Lorrae, before we go, is there anything that you would like to add, particularly from your perspective of emerging policy and funding, where you think some change could make a real difference?
I think that the funding question is interesting, because actually all of these new pots, they don't really fix the political dynamics or the political issues that we've seen with transport projects in the past. If it goes across local authority areas, how does that fit together? You know, what is the politics behind it and the governance mechanisms behind it? So that's not really a TWA reform, but I think that there is potential there for more assistance to be given to sort of unblock that potential, because I think that still exists even with these new pots of funding available.
Thanks. Well, before we come to an end, the question that you all want to know the answer to, what's the result of the poll? So if I can read this correctly, so the question was, is it time for reform of the TWA, associated rules and guidance? The answer is overwhelmingly yes. We've got 89% yes and 11% no. So think from our audience today, they're with you, Kevin. So you get the vote.
Thank you.
Thank you very much indeed to all our participants. Thank you to Kevin and Lorrae from Womble Bond Dickinson, and Matthew Henderson from Landmark. And thank you very much to all of those who've listened to us on this delightful summer evening. Have a good evening for the rest of it.
Thank you, Neil, for chairing. Thank you very much. Bye, everyone.
Bye.